Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, it's not Friday, but Alex Ooley is joining me. He's fresh back from Detroit, as am I. He got back Sunday. I just got back today, but we've had a decision from the Fifth Circuit that we wanted to talk about, so I asked Alex if he'd be available tonight. He said he would come on, and thank you, Alex, for coming on board today, man.
Yeah, no problem. Thanks for having me, Paul.
So I want to get started today. A couple things. First of all, I want to say congratulations to Andrew Gottlieb. Andrew's a friend of mine and was formerly one of my bosses at SAF. A press release came out today from the Citizens Committee for the Right to Keep and Bear Arms. Andrew's been promoted to the managing director at CCR KBA effective today. So congratulations to Andrew. For those of you who may not be clear, Citizens Committee is the sister organization to SAF. Citizens Committee gets a lot deeper into the state level and the local level than the SAF does. SAF primarily does lawsuits. The CCR KBA does that a little bit. And the CCR KBA primarily deals with the state and local levels, and the SAF does a little bit of that. So the Andrew being promoted is good news, and congratulations, Andrew. And I'm excited to see what you're going to bring to the table. As we get going here, Alex, I want to talk a little bit about we both were in Detroit this past weekend for Rick Ector's women's shooting weekend. What was your impressions of the whole weekend overall, man?
Well, so it was the 12th annual event, or 12th annual Legally Armed in Detroit event, and it was my first time attending, so I wasn't really sure what to expect. I'd seen some stuff on social media about the event, but it's hard to know what to expect until you're there. And it was really amazing to see the turnout and to get to work with the women there in Detroit and to teach them, to give them a good foundation for armed self-defense, to teach them the basics of safe gun handling and marksmanship. And of course, they aren't going to be master marksmen or gun handlers by the time they leave the training, but it gives them a good foundation, and that's really our goal. We want the women to have a positive first experience with firearms, and I think a lot of women got that experience this weekend. I saw a lot of smiles leaving the range, so that was wonderful to see.
One reason I like going there is I can pick up tips and tricks from other trainers about training brand new people to shoot, and I got a lot of that this year. I was able to talk with a lot of different trainers and get their approaches on things and adapt it on the fly to what I do.
Yeah, it's easy to sort of talk about firearms training and not really get a sense for how to do it. And when you actually see it being done well, you have a tendency to sort of incorporate those things into your own training practices. So that's certainly a great takeaway as an instructor as well.
All right, let's go ahead and let's get started on the news, Alex. We did have an announcement come out from the Firearms Policy Coalition today, and our lead story does come from the increasingly freedom-friendly Fifth Circuit. According to a press release from Firearms Policy Coalition, a 3-judge panel voted 2-1 that the ATF has overstepped its bounds when making the current pistol brace rule and sent the case back to a lower court for a decision on if the case is worthy of an injunction, what that injunction, if needed, might look like. This is the same pistol brace rule that both Firearms Policy Coalition and Second Amendment Foundation got an injunction on previously. The Justice Department asked to get kicked up to the Fifth Circuit. It did, and this is the Fifth Circuit. If I'm getting this right, this is the Fifth Circuit saying, yeah, the lower courts got this one right. This is not. The ATF overstepped its bounds, and they kicked it back down for further work on it. Am I getting that right, Alex?
Yeah, mostly. I think it's helpful to give a little bit of background here. Like you said, it's the addressing the same rule, final rule from the ATF that requires registration of pistols equipped with a pistol stabilizing brace. Because for the last decade, the ATF has said that those pistols equipped with pistol stabilizing braces are still pistols. They wouldn't be considered short-barreled rifles that would be subject to regulation by the NFA and a registration and a $200 tax. The ATF changed that rule, or changed their interpretation of that rule, by basically rewriting the rule, and said that those firearms equipped with pistol stabilizing braces having a barrel length of less than 16 inches would now be considered short-barreled rifles. And that rule has been challenged in the courts around the country. As you said, Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America secured an injunction for their members. But what's important to understand about this particular case, the mock case, is that the district court, the lowest level court in the Northern District of Texas, actually denied an injunction initially. And the Firearms Policy Coalition asked the Fifth Circuit to review that denial of the injunction. The Fifth Circuit granted that injunction pending the appeal of the denial, and they had oral argument, and they submitted or reviewed the briefs that were submitted, and then issued a decision today saying, yes, the plaintiffs are likely to prevail on the merits, and are therefore entitled to a preliminary injunction. So they sent it back down to the lower court, Northern District of Texas. But what's interesting about the decision is that it's really just a temporary injunction until the district court can reconsider the injunction at the trial court level. And the Northern District was instructed by the Fifth Circuit to consider not only whether or not the plaintiffs are likely to prevail on the merits, but also the other factors that have to be considered when determining whether or not to grant a preliminary injunction, which include whether or not the plaintiff is likely to suffer irreparable harm without the injunction, and whether the injunction is in the public interest. And I think that the court will ultimately come down on the side in favor of the injunction. What's interesting, too, is that the Northern District initially denied the injunction, saying that the plaintiffs didn't show that they were likely to prevail on the merits because they didn't provide the court with enough history to support their argument. But I think the Firearms Policy Coalition was right in saying that the court had the burden reversed. It's not the plaintiff's burden to show that there's history that supports an injunction. It's the ATF, the government's burden, to show that there is history to support the restriction on the Second Amendment right. So I think this is a good step in the right direction, and I think ultimately the district court in the Northern District of Texas will get this right and continue the injunction while the case is litigated on the merits.
I want to get a quote from the press release here. This is a quote from the order itself. To ensure relative stability, we maintain the preliminary injunction pending appeal that the motions panel issued on May 23, 2023, as clarified by the merits panel on May 26, 2023. This court's injunction will expire in 60 days from the date of this decision, or once the district court rules on a preliminary injunction, whichever occurs first. We direct the district court to rule within 60 days. So what they're saying is this will expire in 60 days, but oh, by the way, and then trying to the scrolling up here, I do not see initially the initial judge on this, but we're directing this judge, don't drag your feet. We want you to act within 60 days so that when this expires, there is a ruling in place.
Yeah, that's right. And I think what's interesting, too, is that this opinion was issued based on the court finding that the plaintiffs were likely to prevail on their Administrative Procedures Act claims, saying that the ATF violated the Administrative Procedures Act because the final rule wasn't consistent with the proposed rule, and there wasn't a time and comment period with respect to the final rule that was actually adopted as opposed to the proposed rule. But the other thing is that Judge Willett, who wrote a concurring opinion, said while the analysis of the APA, the Administrative Procedures Act claim, was enough to maintain the injunction, he also thought, for the record, that the plaintiffs were likely to prevail on the constitutional claims, that is, at least under the Second Amendment, although there are claims under the First and Fifth Amendment. So I think that's good news. The other thing that's, I think, good news too is that the court addressed, although briefly, addressed the possibility of a nationwide injunction, saying that nationwide relief is extraordinary but may be appropriate in some circumstances, depending on the number of members that an organization has and where they are located, i.e. nationwide or more locally. And I think that sort of implicitly gives the district court the go-ahead or permission, so to speak, to issue this as a nationwide injunction.
One other thing I want to discuss with you briefly, and I seen this in a separate news story that I did not get onto the show notes today, but and for the audience, I'm dropping the bomb on Alex. I have not brought this up previously, including when we were discussing anything pre-show. There's a case that is pending, I believe, in front of the Supreme Court about something called the Chevron defense, that is going to possibly put a bigger restriction on what the federal government can and cannot do as it applies to things like the EPA, things like the ATF issuing their own rules. Can you talk any more about the original Chevron case and what this court decision coming up may look like?
Yeah, so it's called Chevron deference, which is basically deference to administrative authority. And these administrative agencies are put in place because the legislature passes laws and the executive is tasked with enforcing those laws. Well, the government officials aren't necessarily well versed in various technical legal areas. So things like firearms or things like the environment or science or what have you. So these administrative agencies are created so that experts, so-called experts, can help administer these programs and laws. And so this doctrine has developed, the Chevron doctrine has developed, giving wide and broad deference to these administrative agencies. Unfortunately, that deference has helped expand these administrative agencies' power and authority beyond their intended purpose and their intended authority originally. And essentially what these administrative agencies have started to do is not just interpret and enforce the law, but also create law, because they are basically, like the ATF has done here, creating new rules out of thin air when they are claiming to simply interpret the law. So I think what's going on in the courts, and in this case before the Supreme Court, I'm hopeful anyway, that the Supreme Court significantly curtails the deference that we give to these administrative agencies, because they've gone rogue, and they need to be put back in their place, and that includes not just the ATF, but other agencies like the EPA, the FDA, the CDC, etc. I don't know, I'm not intimately familiar with the status of that case before the Supreme Court. I haven't checked on the status of that recently, but I'm optimistic because with the addition of Justice Gorsuch and Amy Coney Barrett, I think that may change the balance on the court enough to curtail administrative agency authority. I know that Justice Gorsuch has been very outspoken on this issue for a number of years before he even was selected for the Supreme Court.
All right, I'm going to move on a little bit to our next story. I got this story off of, let me scroll way down there, NRA ILA, and I'm going to briefly synopsize this because it's a fairly long story. The Bipartisan Safer Communities Act that was passed last year had language in it that stated in order to qualify for funding a state's red flag law, that red flag law had to have protections in it, basically disallowing ex parte, or that's legal, my understanding is with one person not present, orders, or the ability of the government to go in and take your rights away without you being present in a hearing to speak for yourself or be represented by an attorney. The DOJ, however, appears to be issuing out cash to states without the states aligning their laws to allow proper jurisprudence. And there's been a couple of legislators on the federal level that have sent out, Senators Marshall and Representative Mooney have requested the DOJ respond to their concerns no later than August 18th. This is one state they bring up is Montana is getting this money, and Montana does not have a red flag law, period. It's a little bit confusing to me how this money can go out to secure red flag laws in states that don't have them, and how they can go out to the states that don't make these changes. Have you been able to look at this at all, Alex?
Yeah, so the concern here, right, is that the Bipartisan Safer Communities Act has this requirement in it that states, in order to get the grant funding, that they have to have strict due process requirements in their red flag law. Mm-hmm. And the sort of the carrot and stick. The federal government wants them to implement red flag laws, but they don't get the funding unless the red flag law has due process in it. The problem is that there are states, like you say, that Montana doesn't have one at all, but the more problematic situation is the states that have red flag laws, but without the strict due process requirements. So these states are getting funding to implement these red flag laws without the due process requirements in the Bipartisan Safer Communities Act. Now, I don't and haven't seen any red flag law with sufficient due process protections because the way that these work by nature is that they take away the firearm and then give you process later. And that's not due process. You're supposed to have the process, the fair procedure before your rights are taken. That's what the Constitution says. That's what the Bill of Rights says. In multiple places, the Fifth and 14th Amendment explicitly protect due process. So this funding is being handed out in an effort to coerce these states or to incentivize these states to implement red flag laws even where there are not adequate due process protections.
Yeah, I was reading an article online earlier today about the 14th Amendment, and it does slam home you cannot be deprived of life, liberty, or property without due process provisions. And I don't think, personally, again, this is my own opinion, this is not the opinion of the SAF or anybody else, we shouldn't be executing anybody for any crimes because people make mistakes, including jurors, including judges, including attorneys. I don't believe there's any crime, there's any level of crime that rises up to we need to kill somebody for this. Because if a mistake's made, you cannot take that punishment back. However, you know, that we do live in a gray world, not a black and black and white world. So I mean, it's there. There are, I guess, cases that can be argued for the death penalty, but we've gone well afield here. So,
But the other concern, and we've talked about this before on the show, Paul, is that these red flag laws are ripe for abuse. Number one, that they can be based on flimsy or completely false allegations, and that your property, as you said, can be taken away before process is provided, before you have a hearing, before you have counsel, before you have an opportunity to present evidence and testimony to a judge. And the other problem, of course, is that judges often err on the side of caution. Even if they are somewhat conservative judges, they don't want to be seen as having blood on their hands if somebody does use a firearm in an awful way and hurt somebody. So even where the evidence may not support the deprivation of your property, the judges will sometimes nevertheless support that deprivation in an abundance of caution.
you get a couple comments in here from Warsaw Patriot. First comment, anybody who asks me of what to think about red flag laws, they are dangerous. You might as well SWAT someone. Just like what happened to Duncan Lemp in Maryland. And also followed up with red flag laws are abused and used as a form of swatting, period. And these are absolutely rife when one of the requirements, even in the most restrictive, places like California are trying to get it to where school teachers and school administrators can initiate a red flag seizure or an investigation for a red flag seizure. Even in cases where it's just family. Well, what if you and your wife are getting a divorce? I mean, the situation right there is rife for somebody to lie and rights to be taken without due process, and all of a sudden somebody's right to keep and bear arms, their right to defend themselves is gone.
Yeah, and on top of that, every state has some form of an emergency commitment order. People often know it as the Baker Act provision. That's what it's called in Florida. That's the term that's been popularized. But those emergency mental commitment orders are very well vetted statutes, typically have lots of due process built in, and don't simply focus on the firearm. I mean, because if somebody is truly dangerous, it's not just the firearm that they should be worried about. I mean, they should either be committed to a hospital, a mental institution, or be in jail if they're truly dangerous. And this sort of monomaniacal focus on the firearm is just crazy, and it's a symptom of the vendetta against individual rights and the right to keep and bear arms.
Our next story here, excuse me, this is a BearingArms.com story, a Tom Knighton story. Alaska took a step to protect future gun rights over the weekend as Governor Dunleavy signed a bill that prohibits the state and local government entities from closing lawful firearm businesses or restricting individuals' access to firearms, ammunition, and component parts during declared states of emergency. Alex, why this is significant to me is it's rare, it's exceedingly rare for any level of government to give up power. And that's exactly what the state of Alaska did this legislative session, and when Governor Dunleavy signed the bill this past weekend, is saying, look, we believe these rights should not be touched whether or not there's a state of emergency. So going forward, they won't be able to be.
Yeah, I think that's exactly right. There's a saying, and I'm not going to get it exactly right, but basically the saying is, once freedom is lost, you never get it back. And I think that's the corollary to that, like you say, Paul, is that once the government takes the power or asserts the power, they rarely give it up. And it's good to see Alaska do this. This sort of step has been taken by several states since Hurricane Katrina, because the city of New Orleans tried to take people's firearms when they needed them most in the aftermath of Hurricane Katrina. And Indiana, for instance, implemented one of these laws prohibiting the confiscation of firearms during times of emergency. So I think this is a good step, and I think other states have done this. I don't know which ones exactly off the top of my head, but I'm glad to see Alaska join that group of states.
Absolutely. And speaking to your original reference, Katrina and New Orleans, there's a video that made the rounds on YouTube, and I'm sure you can still find it, of police interacting with a grandmother in New Orleans after Katrina. She had a .22 rifle, and they tackled grandma and took her .22 rifle because the mayor declared all guns illegal except for those in possession by police and the military. And so grandma no longer could have her .22 rifle. They tackled her, they took her rifle. And just because of a state of emergency. And yeah, I'm with you. These things, I'm glad to see these things going away. Let's see here. One more story I want to cover today. We got about 5 minutes left. I didn't get this one synopsized, but I'm going to try on the fly to synopsize it. North Dakota's Second Amendment Financial Privacy Act now in effect. This is a story from the 10th Amendment Center.com. On Tuesday, a North Dakota law prohibiting financial institutions operating in the state from requiring a credit card merchant code to track the purchase of firearms and ammunition goes into effect. And I'm going to skip down into the because we've talked about these before. I'm going to skip down the article a little bit. I'm going to read from the middle of the article. Concern about the misuse of firearms databases isn't just paranoia. The Taliban has recently been reported to use a firearm ownership database created by the U.S. government to track down gun owners and confiscate firearms in Afghanistan. This goes to show that even if you trust the people creating the database, it can fall into the wrong hands. In other words, the very existence of a database is a danger. I don't like these databases. I don't think they should be around. I don't think the ATF, which has been illegally building a registry for a couple years now, should have. I think they should be forced to destroy what they have. But even this, again, we don't know where the Taliban got their, if it was built by the U.S. military, how they got it, but yeah, just the existence of any kind of a registry or database is very dangerous.
Yeah, and I think this article illustrates not only why financial privacy is important, but why privacy more broadly is important. I mean, we have all these organizations, we voluntarily give up our data every day to companies like Facebook and Google and Yahoo, etc. So it's not just the banks, but the government is cooperating with these organizations in lots of cases and obtaining information about you without a warrant. So they're just bypassing the warrant requirement to spy on you, essentially. And so this is really, it reminds me of one of my favorite movies. It's called The Lives of Others, and it's basically about the Stasi spying on this artist in eastern bloc of Germany, okay, in Soviet Union at the time. And this is sort of like that, except that they're not using wires inside of your home. They're just using the information that is collected about you through these other organizations and taking that information about you without your knowledge.
Let me get a comment in here from Warsaw Patriot. If they made a database, they might as well let the communist Chinese CCP hack it. Private info exposed. Yeah, just think about it for a second. If there were a database of even these credit card companies, look, this person went and spent a lot of money at Cabela's, went and spent a lot of money at XYZ gun store. Could be for ammunition, could be for weapons, could be for clothing, who knows, but that's all valuable stuff. And gang members, here's that list, here's your target list.
Yeah, that's exactly right. And a lot of people, you always hear people say, well, I don't have anything to hide, I'm not doing anything wrong. Well, that may be true today, but what's considered right and wrong tomorrow may change. I mean, a perfect example of that is with the pistol stabilizing brace. Somebody possessing a pistol with a stabilizing brace last year wasn't doing anything wrong. This year, they would be if they had it and didn't register it. So that's why it's important to be cautious and conscientious about your privacy, that's financial and otherwise, because the government tomorrow may not think that what you are doing today is right.
All right, well, we are down at the bottom of the hour. We've actually gone just a touch long. But, Alex, on our way out the door, if you would, please, your podcast, Forge of Freedom, tell everybody about it and what your last episodes up are.
Yeah, so obviously I care deeply about the right to keep and bear arms, but my passion is more broad than that. I care more broadly about freedom, and I started this podcast at the beginning of the year with the idea of spreading the message of freedom and helping people become familiar with the ideas of freedom so that they can create a freer life and ultimately a freer world. Last week I had the opportunity to have a conversation with Stephen Hallbrook about his book, America's Rifle, The Case for the AR-15. I also had an interview a few weeks ago with Lawrence Reed from the Foundation for Economic Education about his book, Are We Good Enough for Liberty? And I think that the ideas that I'm trying to convey in these podcasts are important to understand, not only to pass on to future generations, but to protect the rights that we have today and hopefully for our children and grandchildren. So if that's something that's of interest to you, check it out. It's on YouTube, Rumble, and on most of the most popular podcast streaming platforms.
Very cool. Thank you again, Alex. Everybody, that's going to wrap up my broadcast for today. Come join me tomorrow and Thursday when we talk more about the news of the day. And this Saturday is we go back to this Friday is the Training Friday with Tom Walls of the Firearms Academy of Seattle. And then Saturday is our regular week in review show. And I've got Coop Cooper going to be coming in. Coop is C&T Designs and Arms. And I haven't filled out the other two people who will be joining me yet, but I look forward to talking to you all this weekend for the Week in Review show as well. Thanks for watching, everybody. Podcast listeners, thanks for listening, and we will see you next time.